Ladies and gentlemen, the arguments have been completed, and I now will instruct you as the law that applies to this case. Members of the jury, the evidence and the arguments in this case have been completed, and I now will instruct you as to the law. The law that applies to this case is stated in these instructions, and it is your duty to follow all of them. You must not single out certain instructions and disregard others. It is your duty to determine the facts and to determine them only from the evidence in this case. You are to apply the law to the facts and in this way decide the case. You are not to concern yourselves with possible punishment or sentence for the offense charged during your deliberations. It is the function of the trial judge to determine the sentence should there be a verdict of guilty. Neither sympathy nor prejudice should influence you. You should not be influenced by any person's race, color, religion, or national ancestry, gender, or sexual orientation. From time to time, it has been the duty of this court to rule on the admissibility of evidence. You should not concern yourselves with the reasons for these rulings. You should disregard questions and exhibits which were withdrawn or to which objections were sustained. You should disregard testimony and exhibits which this court has refused or stricken. The evidence which you should consider consists only of the testimony of the witnesses and the exhibits which this court has received. You should consider all the evidence in the light of your own observations and experience in life. Neither by these instructions, nor by any ruling or remark which I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Faithful performance by you of your duties as jurors is vital to the administration of justice. Only you are the judges of the believability of the witnesses and of the weight to be given to the testimony of each of them. In considering the testimony of any witness, you may take into account his ability and opportunity to observe, his memory, his manner while testifying, any interest, bias, or prejudice he may have, and the reasonableness of his testimony considered in the light of all the evidence in the case. You should judge the testimony of the defendant in the same manner as you judge the testimony of any other witness. Opening statements are made by the attorneys to acquaint you with the facts they expect to prove. Closing arguments are made by the attorneys to discuss the facts and circumstances in the case and should be confined to the evidence and to reasonable inferences to be drawn from the evidence. Neither opening statements nor closing arguments are evidence, and any statement or argument made by the attorneys which is not based on the evidence should be disregarded. Those of you who took notes during the trial may use your notes to refresh your memory during jury deliberations. Each juror should rely on his or her recollection of the evidence. Just because a juror has taken notes does not necessarily mean that his or her recollection of the evidence is any better or more accurate than the recollection of a juror who did not take notes. When you are discharged from further services in this case, your notes will be collected by the deputy and destroyed. Throughout that process, your notes will remain confidential and no one will be allowed to see them. The defendant is charged with the offense of first-degree murder. The defendant has pleaded not guilty. Under the law, a person charged with first-degree murder may be found 1, not guilty of first-degree murder, or 2, guilty of second-degree murder, or 3, I'm sorry, I have to read this again. All right. The defendant is charged with the offense of first-degree murder. The defendant has pleaded not guilty. Under the law, a person charged with first-degree murder may be found 1, not guilty of first-degree murder, or 2, guilty of first-degree murder, or 3, guilty of second-degree murder. The defendant is also charged with the offenses of aggravated battery with a firearm. The defendant has pleaded not guilty to those charges. The defendant is also charged with the offense of official misconduct. The defendant has pleaded not guilty to that charge. The state has also alleged that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person. The defendant has denied the allegation. The charges against the defendant in this case are contained in a document called the indictment. This document is the formal method of charging the defendant and placing the defendant on trial. It is not any evidence against the defendant. The defendant is presumed to be innocent of the charges against him. This presumption remains with him throughout every stage of the trial and during your deliberations on the verdict, and it is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that he is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. The defendant is presumed to be innocent of the charge against him of first-degree murder. This presumption remains with him throughout every stage of the trial and during your deliberations on the verdict, and it is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving that the defendant is guilty of first-degree murder, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. If the state proves beyond a reasonable doubt that the defendant is guilty of first-degree murder, the defendant then has the burden of proving by a preponderance of the evidence that a mitigating factor is present, so that he is guilty of the lesser offense of second-degree murder and not guilty of first-degree murder. In deciding whether a mitigating factor is present, you should consider all the evidence bearing on this question. The phrase preponderance of the evidence means whether, considering all the evidence in this case, the proposition on which the defendant has a burden of proof is more probably true than not true. The state has also alleged that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person. The defendant is presumed to be innocent of this allegation. This presumption remains with the defendant throughout every stage of the trial and during your deliberations on the verdict, and is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that the allegation is proven. The state has the burden of proving the allegation beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to disprove the allegation. Circumstantial evidence is proof of facts or circumstances which give rise to a reasonable inference of other facts, which tend to show the guilt or innocence of the defendant. Circumstantial evidence should be considered by you together with all the other evidence in the case in arriving at your verdict. You have before you evidence that the defendant made statements relating to the offenses charged in the indictment. It is for you to determine whether the defendant made the statements, and if so, what weight should be given to the statements. In determining the weight to be given to a statement, you should consider all the circumstances under which it was made. It is proper for an attorney to interview or attempt to interview a witness for the purposes of learning the testimony the witness will give. However, the law does not require a witness to speak to an attorney before testifying. The believability of a witness may be challenged by evidence that on some former occasion he made a statement that was not consistent with his testimony in this case. Evidence of this kind ordinarily may be considered by you only for a limited purpose of deciding the weight to be given to the testimony you heard from the witness in this courtroom. However, you may consider a witness's earlier inconsistent statement as evidence without this limitation when the statement was made under oath at a trial, hearing, or proceeding, or the statement narrates, describes, or explains an event or condition the witness had personal knowledge of, and the witness acknowledged under oath that he made the statement. It is for you to determine whether the witness made the earlier statement, and if so, what weight should be given to that statement. In determining the weight to be given to an earlier statement, you should consider all the circumstances under which it was made. In this case, the state must prove beyond a reasonable doubt the proposition that the defendant was not justified in using the force which he used. You have heard testimony of Laquan McDonald's alleged prior acts of violence. It is for you to determine whether Laquan McDonald committed those acts. If you determine that Laquan McDonald committed those acts, you may consider that evidence in deciding whether the state has proved beyond a reasonable doubt that the defendant was not justified in using the force which he used. An electronic recording has been admitted into evidence. In addition to the electronic recording, you are being given a transcript of the electronic recording. The transcript only represents what the transcriber believes was said on the electronic recording and merely serves as an aid when you listen to the electronic recording. The electronic recording, and not the transcript, is the evidence. If you perceive a conflict between the electronic recording and the transcript, the electronic recording controls. The term public employee means a person other than a public officer who is authorized to perform any official function on behalf of and is paid by the state or any of its political subdivisions. A person is considered to personally discharge a firearm when he, while armed with a firearm, knowingly fires a firearm, causing the ammunition projectile to be forcibly expelled from the firearm. The word firearm means any device by whatever name known, which is designed to expel a projectile or projectiles by action of an explosion, expansion of gas, or escape of gas. A peace officer need not retreat or desist from efforts to make a lawful arrest because of resistance or threatened resistance to the arrest. He is justified in the use of any force which he reasonably believes to be necessary to effect the arrest or defend himself and or another from bodily harm while making the arrest. However, he is justified in using force likely to cause death or great bodily harm only when he reasonably believes that such force is necessary to prevent 1, death or great bodily harm to himself or another, or 2, the arrest from being defeated by resistance or escape, and a person to be arrested has committed or attempted aggravated assault which involves the infliction or threatened infliction of great bodily harm, or 3, the arrest from being defeated by resistance or escape, and a person to be arrested is attempting to escape by using deadly weapon or otherwise indicates that he will endanger human life or inflict great bodily harm unless arrested without delay. The phrase reasonably believes or reasonably believes means that a person concerned, acting as a reasonable person, believes the described facts exist. A mitigating factor exists so as to reduce the offense of first-degree murder to the lesser offense of second-degree murder if, at the time of the killing of the defendant, the defendant believes that circumstances exist which would justify the deadly force he uses, but his belief that such circumstances exist is unreasonable. In order for you to find the acts of the defendant caused the death of Laquan McDonald, the state must prove beyond a reasonable doubt that the defendant's acts were a contributing cause of the death, and the death did not result from a cause unconnected with the defendant. However, it is not necessary that you find the acts of the defendant were the sole and immediate cause of death. Force which is likely to cause death or great bodily harm includes the firing of a firearm in the direction of a person to be arrested, even though there is no intent exists to kill or inflict great bodily harm. A person commits the offense of first-degree murder when he kills an individual without lawful justification if, in performing the acts which caused the death, he intended to kill or do great bodily harm to that individual, or he knows that such acts would cause death to that individual, or he knows that such acts create a strong probability of death or great bodily harm to that individual. To sustain the charge of first-degree murder or the charge of second-degree murder, the state must prove the following proposition. First proposition, that the defendant performed the acts which caused the death of Laquan McDonald, and second proposition, that when the defendant did so, he intended to kill or do great bodily harm to Laquan McDonald, or he knew that such acts would cause death to Laquan McDonald, or he knew that such acts created a strong probability of death or great bodily harm to Laquan McDonald. And third proposition, that the defendant was not justified in using the force which he used. If you find from your consideration of all the evidence that any one of these propositions has not been proven beyond a reasonable doubt, Your deliberations on these charges should end, and you should return a verdict of not guilty of first-degree murder. If you find from your consideration of all the evidence that each one of these propositions has been proven beyond a reasonable doubt, then you should go on with your deliberations to decide whether a mitigating factor has been proved so that the defendant is guilty of the lesser offense of second-degree murder instead of first-degree murder. You may not consider whether the defendant is guilty of the lesser offense of second-degree murder until and unless you have first determined that the state has proven beyond a reasonable doubt each of the previously stated propositions. The defendant has the burden of proving by a preponderance of the evidence that a mitigating factor is present so that he is guilty of the lesser offense of second-degree murder instead of first-degree murder. By this I mean, you must be persuaded, considering all the evidence in this case, that it is more probably true than not true that the following mitigating factor is present. That the defendant, at the time he performed the acts which caused the death of Laquan McDonald, believed the circumstances to be such that they justified deadly force he used, but his belief that such circumstances existed was unreasonable. Excuse me. If you find from your consideration of all the evidence that the defendant has proved by a preponderance of the evidence that a mitigating factor is present so that he is guilty of the lesser offense of second-degree murder instead of first-degree murder, you should find the defendant guilty of second-degree murder. If you find from your consideration of all the evidence that the defendant has not proved by preponderance of the evidence that the mitigating factor is present so that he is guilty of the lesser offense of second-degree murder instead of first-degree murder, you should find the defendant guilty of first-degree murder. A person commits the offense of aggravated battery with a firearm when he, by means of discharging a firearm, intentionally causes injury to another person. A public employee commits the offense of official misconduct when in his official capacity he knowingly performs an act which he knows is forbidden by law to perform. To sustain the charge of official misconduct, the state must prove the following proposition. First proposition, that the defendant was a public employee, and second proposition, that when in his official capacity, the defendant knowingly performed an act which he knew he was forbidden to perform, and third proposition, that the defendant was not justified in using the force which he used. If you find from your consideration of all the evidence that each one of these propositions has been proven beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proven beyond a reasonable doubt, you should find the defendant not guilty. Could I have the attorneys over here for a second, please? Ladies and gentlemen, these are the propositions that are necessary to sustain the charge of aggravated battery with a firearm. To sustain the charge of aggravated battery with a firearm, the state must prove the following propositions. First proposition, that the defendant intentionally caused injury to another person, and second proposition, that the defendant did so by discharging a firearm, and third proposition, that the defendant was not justified in using the force which he used. If you find from your consideration of all the evidence that each one of these propositions has been proven beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proven beyond a reasonable doubt, you should find the defendant not guilty. Ladies and gentlemen, when you retire to the jury room, you first will elect one of your members as your foreperson. She or he will preside during your deliberations on your verdict. Your agreement on a verdict must be unanimous. Your verdict must be in writing and signed by all of you, including your foreperson. The defendant is charged with the offense of first-degree murder. Under the law, a person charged with first-degree murder may be found 1, not guilty of first-degree murder, or 2, guilty of first-degree murder, or 3, guilty of second-degree murder. Accordingly, you will be provided 3 verdict forms: not guilty of first-degree murder, guilty of first-degree murder, and guilty of second-degree murder. From these 3 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other 2 verdict forms. Sign only one of these verdict forms. The defendant is also charged with the offense of aggravated battery with a firearm. There's 16 counts. You receive 2 forms of verdict as to each count. You will be provided with both a not guilty of aggravated battery with a firearm and a guilty of aggravated battery with a firearm as to each count. From these 2 verdict forms, you should select the one verdict form that reflects your verdict pertaining to the charge of aggravated battery with a firearm, as I have stated. You should not write on at all on the other verdict form pertaining to the charge of aggravated battery with a firearm. The defendant is also charged with the offense of official misconduct. You will receive 2 forms of verdict as to this charge. You will be provided with both a not guilty of official misconduct and a guilty of official misconduct form of verdict. From these 2 verdict forms, you should select the one verdict form that reflects your verdict pertaining to the charge of official misconduct and sign it as I have stated. You should not write at all on the other verdict forms pertaining to the charge of official misconduct. The state has also alleged that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person. If you find the defendant is not guilty of the offense of first-degree murder, you should not consider the state's additional allegation regarding the offense of first-degree murder. If you find the defendant is guilty of first-degree murder, you should then go on with your deliberations to decide whether the state has proven beyond a reasonable doubt the allegation that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person. Accordingly, you will be provided with 2 verdict forms. We, the jury, find the allegation that the defendant personally discharged a firearm that approximately caused death to another person was not proven, and we, the jury, find the defendant personally discharged a firearm that approximately caused death to another person was proven. From these 2 verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other verdict form. Sign only one of these verdict forms. Your agreement on a verdict as to the allegation must be unanimous. Your verdict must be in writing and signed by all of you, including your foreperson. Ladies and gentlemen, there's one more instruction that has to be given. We, the jury, find the defendant, Jason Van Dyke, not guilty of first-degree murder. We, the jury, find the defendant, Jason Van Dyke, guilty of first-degree murder. We, the jury, find the defendant, Jason Van Dyke, guilty of second-degree murder. We, the jury, find the allegation that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person was not proven. We, the jury, find the allegation that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person was proven. Ladies and gentlemen, these are the aggravated battery with a firearm verdict forms. We, the jury, find the defendant, Jason Van Dyke, not guilty of aggravated battery with a firearm. This pertains to the first shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm. This pertains to the first shot. This pertains to the second shot. We, the jury, find the defendant, Jason Van Dyke, not guilty of aggravated battery with a firearm. This pertains to the second shot. We, the jury, find the defendant, Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the third shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, this pertains to the third shot. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the fourth shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. This is the fourth shot also. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the fifth shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, the fifth shot. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the sixth shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. This pertains to the sixth shot also. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the seventh shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. This pertains to the seventh shot also. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the eighth shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. This pertains to the eighth shot also. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. This pertains to the ninth shot. We, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, pertaining to the ninth shot. We, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. Pertaining to the 10th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, the 10th shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. To the 11th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, pertaining to the 11th shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. Pertaining to the 12th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, the 12th shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. To the 13th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, the 13th shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. As in the 14th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, pertaining to the fourth shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. As to the 15th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, pertaining to the 15th shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. Pertaining to the 16th shot, we, the jury, find the defendant Jason Van Dyke not guilty of aggravated battery with a firearm. Again, pertaining to the 16th shot, we, the jury, find the defendant Jason Van Dyke guilty of aggravated battery with a firearm. The next jury, two jury verdicts are: we, the jury, find the defendant Jason Van Dyke not guilty of official misconduct, and we, the jury, find the defendant Jason Van Dyke guilty of official misconduct.